The morning of the hearing, my sister-in-law was already laughing. Not nervous. Laughing, not anxious laughing. The kind of laughing that meant she thought it was already done. She was standing outside the courtroom door in a blazer. She clearly bought just for the occasion, whispering something to my brother. And when she saw me walk down the hallway alone, no attorney, just a folder tucked under my arm, she leaned toward him and said something I wasn't supposed to hear. I heard it anyway. She actually showed up by herself. This is going to be embarrassing for her. My brother didn't say anything. He just adjusted his tie and looked away. That was almost worse. I kept walking. I found a seat on the left side of the courtroom, set my folder on the table, and folded my hands on top of it. I had been waiting 3 years for this day. I was not going to let her see my hands shake. Let me back up. My father-in-law, Gerald, passed away 18 months before that hearing. He was 74. He had built a small construction business over 40 years, owned a house outright, had a retirement account, and had written well, that was very clear about what he wanted. He had revised it twice in the last 5 years of his life, and both times he had his attorney present, a notary present, and 2 witnesses. Gerald was not a careless man. He understood exactly what he was doing. What Gerald wanted was simple. The house would go to me, not to his son, my husband Daniel, but to me, specifically because Daniel and I had moved in 4 years before Gerald died to help care for him after his first stroke. We had converted the garage into a proper bedroom for him so he wouldn't have to manage stairs. I had driven him to every appointment, every single one. Physical therapy, cardiology, the ophthalmologist, the quarterly labs. Daniel worked construction, long hours, often out of town. I was the one who was there. Gerald knew that. He put it in writing because he wanted to make sure I was protected. He also left a portion of his savings to Daniel, a smaller amount to his daughter, my sister-in-law Renee's husband side, and specific personal items to various people. It was not a complicated will. It was not ambiguous. It was the document of a man who had thought carefully about the people in his life and what he wanted to leave them. Renee did not agree with any of it. Renee was not Gerald's daughter. She was Daniel's wife, which made her my sister-in-law by marriage. She had been in Gerald's life for 11 years, and she had strong opinions about what she deserved from those 11 years. She had also been the one to suggest twice that Gerald might want to update his estate plan after Daniel and I separated. Briefly, 9 months, 2 years before he died. And during that separation, Renee had apparently had several long conversations with Gerald about the future. Gerald did not update his will. During that period, Renee was not happy about that. What Renee did instead, 6 weeks after Gerald passed, was file a petition contesting the will. The grounds were undue influence, she claimed. I had manipulated Gerald into leaving me the house. She also filed at the same time an eviction notice. She claimed that because the estate was in probate and the will was being contested, I had no legal right to remain in the property and should vacate within 30 days. I found out about the eviction filing on a Thursday afternoon when a process server knocked on the door. I stood there on the porch reading the document 3 times. Then I went inside, sat down at Gerald's kitchen table, and called the attorney who had drafted his will. His name was Mr. Calloway. He had been Gerald's attorney for over 20 years. When I explained what had happened, there was a pause on his end of the line, and then he said very calmly, "She filed an eviction notice against the named beneficiary of an estate currently in probate." I said, "Yes." He said, "I'll need you to come in Monday morning." Over the next several weeks, I learned more about probate law than I ever expected to. No, I learned that contesting a will requires actual legal grounds, not just disagreement with the outcome. I learned that undue influence has a specific legal definition and that it requires, demonstrating not just that someone had access to the deceased, but that they had actively exploited a vulnerability to override the person's independent judgment. I learned that Gerald had been evaluated by his physician before signing the second revision of his will, and that the physician's notes documented he was mentally competent and was making decisions without apparent external pressure. I also learned that the eviction filing had procedural problems, significant ones. Mr. Calloway explained it carefully. The property was part of the estate. An interested party in a probate dispute cannot unilaterally file to remove a named beneficiary from estate property while the probate is pending without specific court authorization. The filing as submitted was not only premature, it contained information that was at minimum misleading. He looked at me over his glasses and said, "Do you know who prepared this filing?" I said I assumed Renee had an attorney. He said, "The filing lists a preparer. I'd like you to look at this name and tell me if you recognize it." I looked. The name listed as the filing preparer was a paralegal at a legal document service, not a licensed attorney. That, in itself, was not unusual for certain filings. But the contact information listed the address, the phone number, the associated email. Those belonged to a business that had been dissolved 8 months earlier. The filing was effectively attributed to an entity that no longer existed. Mr. Calloway did not tell me what to do with that information. He simply suggested I keep a copy of everything, document the timeline, and be very thorough in what I brought to the probate hearing. I was thorough. I spent 6 weeks being thorough. I requested records. I cross-referenced dates. I found the original dissolution paperwork for the document service company. I printed the state business registry page showing the dissolution date. I printed the eviction filing. I put them side by side on Gerald's kitchen table and photographed them with my phone. Then I put everything in a folder and I waited. The morning of the hearing arrived. My brother Daniel had agreed to appear jointly with Renee. They were presenting themselves as unified in the contest. He had not spoken to me directly in 4 months. I understood that. What I did not fully understand until I sat in that courtroom and watched them take their seats together was how complete that alignment had become. He did not look at me once. The bailiff called the case. The Judge Merritt, was a woman in her early 60s who moved through paperwork the way people do when they have been doing something for a long time and are not easily distracted. She reviewed the initial filings, asked the clerk to confirm the exhibit list, and then looked up. This is a will contest on grounds of undue influence, and there is also a pending eviction matter connected to the estate property. Is that correct? Renee's attorney said, yes. Judge Merritt said, before we address the substance of the contest, I want to address the eviction filing. I have questions about the procedural basis. Renee's attorney stood. He was confident. He had a prepared explanation. He said that the filing was a protective measure to preserve estate assets during the probate period and that the named beneficiaries continued occupation of the property constituted a complication. Judge Merritt looked at him for a moment. Then she said, "Counsel, who prepared this filing?" He said the filing had been prepared by a document services firm engaged by his client prior to retaining his office. The name on the filing is Meridian Legal Document Services. The judge said, "Are you aware of the current registration status of that entity?" There was a pause. He said he was not personally familiar with the details of that particular service. The judge asked the clerk to pull up the state business registry. The clerk typed. The screen on the wall loaded. Meridian Legal Document Services, dissolution date 14 months prior. The judge looked at the screen. Then she looked at the filing. Then she looked at Renee's attorney. "Counsel, This filing identifies a preparer that was not a legally operating entity at the time of preparation. The contact information listed does not correspond to any currently registered business. This document was submitted to this court as a properly prepared legal filing. Can you explain that? He said he would need to review the matter further. She said, I'd like to know who actually prepared this document because the entity named here could not have done so. The silence in the courtroom was not the comfortable kind. Renee was no longer leaning back in her chair. Judge Merritt asked the clerk to flag the filing for review by the court administrator and noted for the record that the preparation attribution was inconsistent with verified registration records. Then she moved to the substance of the will contest. This part took time. Renee's attorney argued undue influence based on the amount of time I had spent with Gerald, my role as his primary caregiver, and the claim that Gerald's cognitive decline in his final years made him susceptible to suggestion. He called this a pattern of isolation and dependency. Mr. Calloway stood up and said, Your Honor, may I submit the attending physician's notes from the 12 months preceding the most recent will revision. He submitted them. The physician's notes documented 8 separate appointments. In 7 of them, the physician's observations included explicit reference to Gerald's mental acuity, his ability to articulate his own decisions, and the absence of any signs of confusion or undue compliance. In the 8th, Gerald had mentioned unprompted that he had recently reviewed his estate documents and was satisfied with their contents. Mr. Calloway also submitted the notarized certification from the signing of the revised will, which included a statement from both witnesses that Gerald had reviewed the document independently, had asked clarifying questions, and had signed without visible hesitation or apparent pressure. Judge Merritt read through both sets of documents without comment. Then she asked Renee's attorney, what specific evidence do you have that the testator's independent judgment was overridden? He referenced the caregiver relationship. He referenced the time spent together. He referenced the fact that the beneficiary stood to gain from the arrangement. The judge said, Counsel, every beneficiary in every will stands to gain. That is what a beneficiary is. What evidence do you have of override of independent judgment? He did not have a direct answer for that. She moved on. The contest took the remainder of the morning. By the time both sides had presented, Judge Merritt had a stack of documents in front of her that she had read carefully and annotated with a pen. She kept clicking. She did not appear rushed. She did not appear uncertain. She said, I'm going to be direct. A will contest on grounds of undue influence requires more than proximity and care. It requires evidence that the testator's will was supplanted by someone else's will. What has been presented here is a caregiver relationship with a beneficiary outcome. Absent affirmative evidence of manipulation, that is not sufficient grounds to void a properly executed document signed by a competent adult in the presence of a notary and 2 witnesses with physician documentation of mental competency. She paused. The contest is denied. Renee made a sound. I don't know how to describe it exactly. It was not a word. It was the sound of someone who had been completely certain of something, discovering they were wrong. Her attorney immediately moved to preserve the right to appeal. Judge Merritt said that was his client's prerogative, and then she said, I also want to return to the eviction filing. Given the irregularities identified regarding the preparer attribution, I am referring this filing to the court administrator for further review. I am additionally noting for the record that filing a misleading document in a probate proceeding, regardless of intent, is a matter this court takes seriously. She looked directly at Renee's side of the room when she said, Nobody over there said anything. What happened after that unfolded over the following several weeks, not all at once. The court administrator's review of the eviction filing found that the document had been prepared using templates downloaded after the dissolution of the company whose name appeared on it, meaning someone had used that company's branding and information to create the appearance of professional preparation on a document that was in fact self-prepared. The administrator escalated the review. There were conversations about whether the submission constituted a fraudulent filing. I was not present for most of that. Mr. Calloway kept me informed, but he handled the details. What I do know is that Renee's attorney withdrew from the representation shortly after the escalation began. I know that. Renee and Daniel hired a different attorney. The appeal, I know the appeal, was filed and subsequently dropped 5 months later. I also know that the house is mine. I know that because I am sitting in it right now, in Gerald's kitchen at the same table where I used to help him with his medication schedule and his appointment reminders and the crossword puzzle he did every Sunday morning until the last year of his life, when his hands shook too much to write. The table is scratched in the corner where he once set down a coffee mug that was too hot, and we laughed about it. And then I put a coaster there, and he used it every day after without being asked. I have thought a lot about what I would have said to Gerald if he had known what was coming. I think he would have shrugged. He was not a man who was surprised by much. He had told me once, about 2 years before he died, that the hardest thing about getting old was watching people reveal themselves. He said it very quietly, like he was just noting a fact. I did not understand fully what he meant then. I understand now. I do not have a dramatic conclusion to offer. I did not stand up in that courtroom and deliver a speech. I did not confront my sister-in-law in the hallway on the way out. I walked to my car, sat in the driver's seat for a few minutes, and then drove home. Mr. Calloway called that evening to confirm the outcome formally and to explain the next steps for transferring the title. Daniel called 3 weeks later. I let it go to voicemail. The message was 40 seconds long, and I have not listened to it since the first time. What I want to say to anyone watching this is not about revenge. It is not about winning. It is about the specific exhaustion of being told your experience didn't happen the way you experienced it, about spending months being described as a manipulative person by people who had never once sat in a hospital waiting room at 7 o'clock in the morning because they had driven someone there before the day started, about being handed an eviction notice for a house you had made into a home for someone who needed one. The paperwork saved me. Literally, the paperwork. Gerald's physician kept notes. Gerald's attorney kept records. Gerald himself had been clear and consistent and deliberate. And when all of that was laid in front of a judge who was doing her job, it was enough. Keep your records. Keep your documentation. Keep every email, every note, every calendar entry. Not because you think you will need them, but because the person who intends to rewrite the story will count on you not having them. Gerald counted on me to be thorough. I hope I was. I think he already knew I would be.